Next Tuesday, trial. Next Tuesday. I'll agree to a stipulation of 7 extra days. You cannot enter an email that was ex parte communication. That's ex parte objection. This is a clown show already, Riojas, and I'm doing my best to sit here.
Your Honor, it was copied to the court. It was copied to the...
Your Honor, it's fucking ex parte communication, and it has nothing to do with it. It was never on the record. It's not a legal motion. It was an email to her court. It is not on the record. She did not reference it in any filings. It's nowhere in here. So I get to admit emails I sent to them? No. This has nothing to do with motion to dismiss with or without prejudice. This is all bullshit trying to get me to go off, and I'm going to go off even crazier than right now if this shit doesn't stop immediately.
Your Honor, the state is trying to make a record.
This woman is off her meds. This is straight gaslighting, bullshit, time waste. Riojas, I stood right here 3 times and told you we wouldn't have trial today, right? Because they were going to weasel their fucking way out of it. I'm a man of my word. You're excused from class, Mary. Hope you learned a valuable lesson. Not to f with Lane Myers. Because you'll be all over the internet looking dumb. And now your ass got a bar complaint for no probable cause. Now go sit in timeout, Mary, and think about what you did. How you prosecuted an innocent man and wasted his time for 6 months, only to get found out looking stupid.
911, what's your emergency?
No! You gotta do.
Everyone's favorite pro se attorney Lane is back for another hearing. This hearing is a motion to dismiss filed by Tucson City.
Now, the prosecution filed a motion to dismiss the criminal charges in the O'Reilly's case. But there's a catch.
They want this motion to be dismissed without prejudice, meaning they can refile the charges. Lane is obviously going to be arguing to dismiss with prejudice, and it's a motion he's already filed.
Now, you can barely hear the prosecutor during the first 13 minutes of this hearing. So we're starting the hearing after that.
If you would like to hear the hearing in its entirety, make sure to go over to Lane's channel and check it out.
We're on the same page, Mary.
The first motion was submitted by defendant on August 19th, where he asked Judge Mayhew to recuse herself. On August 21st, defendant sent an email to the court, to the judge, and to the state demanding
Objection, hearsay, outside of the, and that's nothing on the record, that's not in the record, and everything they just said is not on the record about Judge Mayhew. There's nothing on the record that I asked Judge Mayhew. This is not in, you cannot enter an email that was ex parte communication. That's ex parte objection. This is a clown show already, Riojas, and I'm doing my best to sit here.
Your Honor, it was copied to the court. It was copied to the...
Your Honor, it's it's ex parte communication, and it has nothing to do with it. It was never on the record. It's not a legal motion. It was an email to her court. It is not on the record. She did not reference it in any filings. It's nowhere in here. This is sending an so I get to admit emails I sent to them? No. This has nothing to do with motion to dismiss with or without prejudice. This is all bullshit trying to get me to go off, and I'm going to go off even crazier than right now if this shit doesn't stop immediately.
Your Honor, the state is trying to make a record.
This woman is off her meds. This is straight gaslighting, bullshit, time waste. Riojas, I stood right here 3 times and told you we wouldn't have trial today, right? Because they were going to weasel their fucking way out of it.
And Lane's not lying. This is him in the last hearing telling Judge Riojas there would be no trial, which he also echoed in the first hearing to Prosecutor Matthew Walker.
It shouldn't take more than 5 minutes because we're not going to even have trial because they're going to get all their witnesses excluded.
So, Mr. Myers, 10th and 11th?
So do we show up for trial? If I'm the only one that's allowed to show up, there's no trial, right? Because didn't you tell me no witnesses, no trial?
Right, there's no witness.
Right, okay.
Trial.
Yeah, there won't be no trial, but we can pretend there's going to be.
So we'll set December 10th as a trial.
There's a better chance of me growing wings and flying out of this courtroom than us having a trial. I'm a man of my word, and I'm always right.
Should we ask your wife that question?
Hey, right now she's going to agree with me. She already put bar complaints on him this morning for this clown shit.
Okay. All right. So you object to states?
Of course, it's an email. Can you even prove that was sent by me? No, it's not on the record. Prove that I sent that. Have the FBI forensically analyze that and prove that it was sent by me. And we already went over this in 3 hearings.
Judge, this is a legal hearing. This is not ex parte. Ex parte means that...
This was supposed to be my trial, and I found out about this court date at 2 o'clock yesterday. I found out about this court date at 2 o'clock yesterday.
Trying to make a record.
They're trying to waste our fucking time.
Stop, Mr. Myers. I don't finish. Then you get speak.
And they're going to be clowns all over the internet, even worse than they already are.
We're moving to admit the 21st.
It's not happening.
It is a legal hearing, and it's not ex parte. Ex parte.
First of all, I found about this hearing yesterday, and I could have brought evidence. Well, where the fuck fuck was my notice of this hearing? I didn't find out about it till the prosecutor emailed me. They closed the case. On the 4th of December, they filed the motion. The case was closed. On the docket, case closed, case dismissed by prosecutors on the court website. I could not file anything on the docket anymore. Case closed, case dismissed. At 2 p.m. yesterday, I got an email for them saying there's a hearing today. What the fuck's a legal hearing, and why didn't I get notice about it ever from the court at any point ever?
This is a tactic the prosecution has been using since the beginning of these hearings, dropping things on Lane at the last possible second so he has no time to prepare. But somehow he still does.
I sent him in and she said this are illegal.
And I know, and you know what they did? They put it on the website as case dismissed. And now if you look on the website right now, they'll show where they corrected that yesterday and they opened the case back up at 2 o'clock. So the fact I'm even here is voluntary.
Okay, stop. First of all, the state has no control over the states.
The court.
The court.
Right, no, I know, that's what I'm saying. So if this is a legal hearing and I could have brought all this evidence, I mean, they filed a one-page motion to dismiss, and this is supposed to be about their motion to dismiss. Why are they talking about email? This sounds like trial.
What they're trying to do.
They're trying to waste our time.
They're arguing that the dismissal should be without.
All right, let's keep it going, because I got some good ones for them.
It's an argument. They're arguing that the dismissal should be without prejudice.
And I'm arguing with, right, and so they're going to try to make their case right. So they have not said a single thing that hasn't been said.
Well, the stuff about that, try to serve the witnesses. We haven't heard that.
Well, that's going to be a good one. Wait till you hear me reply to that. But so all this stuff they're talking about, we talked about at the hearings with Matt Walker. We talked about at the hearing last time about the dates. We sat here for 20 minutes. She had to put her glasses on because she couldn't see the thing.
That's incorrect information. Objection.
She had to walk over there. We had to figure out was June 6th and how many 80 days. It's all on the internet forever. We were sitting there trying to figure out the 180 days and all that. They didn't say. They agreed. Remember, he's not going to make him sign the trial acknowledgement, Your Honor. I agreed 7 days for getting arrested coming in. I said give them 7 days, 180, all that. They didn't bring up a single argument about any of this shit about 180 days at any point. We had the trial acknowledgement signed. Mary is in there. Make sure he signs it, Your Honor. Make sure he signs it. I said there's nothing to sign because there won't be trial because they're going to weasel their way out of it.
Okay, let's make this very simple. The issue, the 180 days is not issued because this is within 180 days.
Today is.
Today is.
Yeah. So they got today to have trial.
Well, unless I agree to the dismissal without prejudice. But I had to grant the dismissal.
I get what you're saying. No.
I
Let's not get it off track. Let them do. They're on what day, whatever they're. But I'm telling you that email is not part of this because it's not on the record. That's
even if I don't consider the email, we're still within 180 days. You agree?
We're not talking about that right now. I'm talking about I'm objecting to that email, right? That's where we were at before we just sidetracked. They want that email admitted. I'm saying it's not. It's ex parte communication with the judge. It's not referenced anywhere in my docket at any point. So it's an email.
Let me ask you a question.
So where's the email I sent her about recording?
Let me ask a question. You said ex parte with the judge. What do you mean by that?
That was my ex parte. That email represents ex parte communication between myself and the judge.
You're not allowed to do ex parte.
Exactly. So it's not allowed to be admitted either because she took herself off the case.
Judge, that is incorrect because it is an email between Mr. Myers and the prosecution. And
No, it's not. It's directly. It says Judge Mayhew.
The state was.
So first it was first this is an email to judge. First they want to admit it as an email to Judge Mayhew. Now they want to admit it as an email to the state. Get your fucking story straight.
It makes no difference. It's irrelevant because they're still within 180 days no matter what.
But that's not what.
But that particular document is going to be showing that there's going to be 30 days of time that should be executed.
It's not.
Over to January the 9th.
It's not.
And we have never.
Why the fuck didn't they bring this up at the last hearing?
Because that was not the.
They did not bring up this stupid ass email and all this extra time. We sit here and agree.
Either way, today was the day set for trial within the time limit.
And they weaseled their way out of it.
They filed their motion to dismiss before the time limit.
6 days.
They filed the motion to dismiss in a time limit.
So let them make their argument so I can make mine.
The sole issue is with or without.
I get it. So keep it going. Keep it going. With email, without, whatever. She was in the middle of talking about this email and giving her a little spiel. Finish their spiel so I can come back at them.
Judge, we're still talking about with or without prejudice, and the one thing that one cannot do under Rule 16 is to dismiss to avoid the purposes of Rule 8.
And that's exactly what you're doing.
We are showing that, number one, first of all, we're not moving to avoid the purposes of Rule 8. Instead, we don't.
Can they present their argument and then I'll argue?
Let them finish. Don't interrupt.
We do not have a witness. Ms. Byrne will continue to talk and to present to the court why 30 days should be excluded from the 19th of August through.
I thought we were deciding motion to dismiss with or without prejudice, not the 180 days. That's my point.
Sir,
That is,
sit down. We'll
that is
talk about
part
it.
of the argument as to even though there should be 30 days excluded.
It's a sad ass argument. Not the evidence, the days.
Based on defense asking Judge Mayhew to recuse.
There's 180 days, Your Honor. Continue. Set trial for next Tuesday. Trial next Tuesday.
30 days of.
Now you can see Lane wants to go to trial and present the evidence. Does that sound like something a guilty person would want to do?
Time that should have been excluded. And so that puts us into January 9th. That would be the time limit.
Let's have trial tomorrow.
But Judge, the state is moving to dismiss not to avoid the purposes of Rule 8, but instead.
To avoid facing Lane Myers at trial.
Have a witness, an essential witness. Not a police officer, an essential witness.
She's.
Not Sergeant Deloria, an essential witness. And she is an essential witness, and the state tried to spend money.
She's being charged with perjury. Can I please?
To try to serve her, and was unsuccessful. Spent money on that.
Ooh, my money.
And
My money.
we also mailed her. And she had the ability to just send us in the certificate of service. Two chances.
So she showed up
But the
at
state
pre-trial
was
hearings, but not trial.
Unsuccessful at the hearing. So we can't go forward without her. That is the reason why the state is moving to dismiss without prejudice. Should the court grant the motion to dismiss without prejudice, the state only has 180 days to refile, which means that the date that would.
So she's suddenly going to show up for court? Not all of a sudden, when she wouldn't show up before?
It's certainly.
She's being charged with perjury. They're not even being honest. She got charged with perjury 2 weeks ago.
Judge, the 180 days would expire on June 8th of 2025. If there is no refile of the case on the two disorderly conducts because the state was unable to procure said witness, then it automatically turns into with prejudice on. Because
All they're doing is avoiding the
cannot
lawsuit.
refile under 13107.
They're just trying to delay the 1983
May
claim.
Ms. Byrne
It won't
make
matter.
the record?
Waste our time some more. Come on, Roni Byrne.
Your Honor, on August 20th, Judge Mayhew scheduled another pretrial for September 18th. As we discussed, the email sent for the second time asking Mayhew to recuse herself was August 21st. On September 6th, the case was reassigned to this court. Your Honor confirmed the September 18th date. The period of August 19th, defendant's motion for Judge Mayhew to recuse herself, and September 18th are delays occasioned on behalf of the defendant. Because the defendant asked Judge Mayhew to recuse herself, time is excluded, and the authorities, Arizona Rules of Criminal Procedure 8A1, generally delays caused or resulting from following time periods are excluded from the time computation, subsection 1, those caused on or behalf of the defendant, whether intentional, not intentional, or willful. In addition, Berger 111 Arizona 335 speaks directly to the request of the defendant to continue for a judge to recuse himself. On August 18th, the evidentiary hearing was set for October 22nd. States include 34 days. Sorry.
Come on now. I have to work
September
today.
18th.
I don't get paid by like
Judge
these people
Mayhew
do.
affirmed and set an EH date for October 22nd. State includes 34 days. On October 22nd, defendant was arrested and the court excluded the time until October 29th. These are 7 days excluded. On October 29th, the bench trial was set for December 10th. Those are 42 days included. However, because the defendant agreed to the selected trial date, the time is excludable at the discretion of the court. As of December 10th.
The defendant did not agree because I wouldn't refuse to sign. See this clown shit, Riojas? You see this clown shit. I refuse to. That's why I refuse to. Now you see why I refuse to sign.
Now, if you saw the last hearing, Lane refused to sign for a new trial because one was already scheduled and didn't happen. and he knew they were going to pull this.
Which takes it to January 9th of 2025. Any dismissal should be without prejudice unless the court finds that the interest of justice requires dismissal with prejudice.
Okay.
Defendant will suffer no prejudice if the case is dismissed without prejudice.
Anything else?
Well, Your Honor, the state would like to reserve the right to respond to defendant's argument should he go into any of his arguments from his motion to dismiss with prejudice.
They brought him up, but I can't.
No, they're not saying that. They just want a chance.
They're just desperate.
Okay, Mr. Myers, go on.
Oh, all right, so I'm going to talk about this. This is their state's motion to extend time to file. They say that they're understaffed. So,
Motion to extend page.
yeah, did you see that?
Yeah.
So how come, before we, so did you receive it from them today, handing it to you?
It was attached to the files I got.
So you got the docket and it was in there?
Yeah.
So how come my motions, that's what I'm saying, Your Honor, the thing was locked, I couldn't file. How did they get to put theirs in there when the case was closed, but I couldn't? When I called up to the court, they said, we can't, the docket's closed, you can't, the case is closed, case is closed. I even called them I sent them an email calling them morons for trying to file an email after the case was closed. So I couldn't file anything, but they could?
What were you gonna file?
I was gonna file a response to their little one-page.
Well, you did, you filed, there's a copy of your objection to the motion to dismiss without prejudice.
No, I didn't. No. That's them. That's what I'm saying. So they filed this little. They filed.
Something you filed, and this motion is.
I filed my notice of appeal because I even filed a notice of appeal because I thought you dismissed it without prejudice. Look, this is what they filed on December 3rd.
I didn't sign it, so it's not.
Right? No, I didn't. You didn't sign it. But what I'm saying is the court granted it. The court, not you. I'm saying the court. She can look it up right now in the court defendant search. It'll show that the case was closed on December 4th, and they had to. It was and now they're. So yesterday at 2 o'clock they called it a computer error. So at 2. So as soon as they filed this and you didn't sign it, now I see now that you set it for a hearing. That's not what was put in the computer. The computer was put case closed. So I couldn't respond to this by filing a response to this, right?
You did.
No, I didn't.
There's one in the file.
I did not. I filed the motion to dismiss with prejudice ahead of time.
Well, that's their, okay, you filed a different response.
No. I started out by filing a motion to dismiss with prejudice.
Right.
They did not respond to it. They filed this instead.
No, that was filed first.
No. November 20th, 24th, or somewhere in there, I filed a motion to dismiss with prejudice first. Then they, instead of responding in the 10 days, filed this, okay, on December 3rd. The docket on the computer, the docket got closed on the 4th, so I couldn't respond to this, and they, I thought, couldn't respond to my motion to dismiss. But somehow on December 5th and 6th, they were able to respond to my motion to dismiss with prejudice, but I wasn't able to respond to their motion to dismiss without prejudice. So I never got a chance to write a brief in response. This is what they filed, though. You have this in there? Yeah, this is their award-winning motion to dismiss without prejudice. Okay? So you have that in there?
Yeah.
Right. So that's so we're here because you set a motion on this, right? And they're saying if I bring up my motion to dismiss with prejudice, which was filed before that, right? And we got to remember there's 2 case numbers here. So I filed the motion to dismiss with prejudice on the case number that ends in 77, okay? I did not file a motion to dismiss on 76 because I wanted trial today. I want to put these people up here because I have the right to question I have not been able to question them. I'm supposed to be here deciding not guilty, 2 trials, not guilty, the case is over, put them on the stand. And I remember, since the first day I met you with Matt Walker, I told you there wouldn't be no trial because there'd be no witnesses and they would play the game. And so I'm going to go through what they just said. Okay, before I even get to their motions, I'm just going to go back. First, I'm going to start with what they said. Okay, so according to because now you have it on the record and I wasn't sure if it got filed because the thing was locked. So you have a copy of their, this. You have a copy of this up there, sir? The state's response to motion to dismiss with prejudice?
Yes.
You do? Okay.
It was filed December 6th.
Right. With Lee. Well, we don't know if you've granted it. Well,
No, I haven't granted it.
Right, because they wanted to exceed the page limit by 22 pages, and they wanted to exceed the time to file it and so in there they say they're understaffed.
Judge, before we go into it,
Is that an objection, Mary?
Objection. The state is asking the court to make a decision as to whether or not the court will allow the exceeding of page limits based on the issues that were raised, as well as it being a day late from the 10 days that the state had.
6 days late.
It was 10 days late because the date that the state received it was not until, to actually receive it, I think he tried to file it as an attachment, didn't work, and so 10 days would have expired on December the 5th. However, we did ask to bump it 1 day.
So they wanted an extra
From
day.
the time that we physically received
Right,
it.
okay,
Not
so-
when you thought-
Let me tell this real quick. I'm going to grant the motion to exceed page limits in time.
Right, that's fine, right, so we can talk about it, that's what I'm saying, so, because I want to be able to, so, okay. So they just admitted that they responded to my motion to dismiss with prejudice on the 6th, they needed extra time, all that, right? But on the 3rd, they had no problem filing this, so instead of responding to my motion to dismiss with prejudice was what they're trying to avoid, the substantive arguments of my motion to dismiss with prejudice. Instead of responding to that, they responded to my motion to dismiss with prejudice. Not with a response, with all these 22-page arguments, that this case law and all this. They responded with a motion to dismiss without prejudice. Okay, they had time before the 10 days to file that. You notice they had the 10 days, they're asking for extra time to file, to respond to the motion with prejudice, which they're so worried about. But they had no problem within that 10 days filing without prejudice, a 1-page thing. And then all of a sudden, they claim they needed to extend time limits because they were understaffed and high workload. But in their own motion here, and I didn't think they'd be silly enough, for lack of a better term, I'm going to try to keep it civil today. I didn't think they would be that silly to come in here and tell you that they've known since November 12th the witness wasn't available. So why didn't they file on November 12th? Why on November 12th when their the most important witness wasn't available? Why didn't they file right then? Why didn't they say, Riojas, she's not available, we're worried about making it seem like we're prejudicing them. We don't want to make it seem like we're pulling any tactical advantages. We don't want to do any of that. Why didn't they immediately say, oh, well, she's not, why'd they wait till December 3rd, 7 days before the trial to decide, well, we better let the judge know our witnesses aren't available, when they knew by their own admission in this thing you just admitted and granted that they knew in this whole affidavit of non-service, they've tried on November 2nd, November 5th, November 9th. In their motion here, they said they've known since November 12th. Well, I guess what I got for you, Riojas, Your Honor. I won't say that, Your Honor. But so, well, they couldn't serve her. Well, guess what? I had Mackenzie O'Brien in a hearing downstairs on November 26th where she committed perjury, and now she's being charged by the Pima County attorneys for perjury in this exact case where she went down and she put an injunction on me, and she admitted she has an 11-minute video. She tried claiming that I waved a gun at her.
Motion, it's not part of this motion.
I agree. It's irrelevant to this point. The issue
No, I'm bringing up the point that Mackenzie would develop. They said they couldn't find her. She was in a hearing downstairs last week. So don't tell me they couldn't find her to serve her.
So they couldn't find Mackenzie to serve her. Well, we know that's a lie because she was just in court a week and a half before this. And they knew she was going to be there because Lane told them she was going to be there. And they even served Lane at that hearing. I mean, come on. If you're going to lie, be better at it.
So, an injunction for harassment. She
was an ex parte hearing?
No, it was me. So hold on. First there was an ex parte hearing, and then there was me there contesting it. And they served me. They served me at the hearing with some paperwork. Why didn't they serve Mackenzie? I came to the hearing, and they gave me service on something in another case. Why didn't they give Mackenzie O'Brien service that they're talking about right now? She was literally downstairs, and they knew it because I sent them a copy of it ahead of time so they could listen to her lie under oath and get herself caught up with perjury. So the issue of not being able to locate Mackenzie O'Brien, she was literally down there with Tom Burning the 26th. November 26th, she was down there with Tom Burning for 3 hours.
Judge, it was an injunction against harassment is what it sounds like, and the state does not present during an injunction against harassment.
No, hold on. They could have served her when she walked out, just like they knew I was in there because they served me something coming out.
I believe that was the court that served him something.
No, it was their thing about this other. It's a different case. It was about they filed the wrong charge or something. Some bullshit we'll deal with in another case.
Amendments?
Huh?
No, it's a different case.
It's a different case.
It's going to be arraigned on 12/12, but that was not when he's saying that Miss O'Brien was in court.
Yes, it was.
I believe.
It's my turn to talk. They talk. Is this an objection?
I'm trying to clarify what happened. So
She was in this building on November 26th, sir.
26?
Yeah.
On her injunction.
She was talking about can't wait to go to trial. You can listen, on November 26th. Stop interrupting me, Mary. This is my turn to talk. I sat there for 10 minutes and let you talk.
On November 26th, she's here.
She's here.
Is he contested?
I contested the injunction, got it dismissed because the judge found her to be, and then she got charged with perjury for the lies in there. And during that hearing, she said she had an 11-minute video, which they bring up in here. They say, oh, she said this is the only video we have. Well, Mackenzie O'Brien admits right downstairs on November 26th, live on the internet, that she has on the record, that she has the whole 11-minute video, and they haven't even tried to get it from her. So as of November 26th, Mackenzie O'Brien was downstairs talking about, yeah, I'm going to go to trial and testify. And well, she's scared now because she's going to get perjury. That she knows that she's going to get, if she comes in here and tells the same story in the police report, it's going to be perjury again, because she just learned that lesson in the injunction for hearing when she went with Judge Surio and claimed, and Judge Surio can remind her. Halfway through the hearing, Judge Surio had to remind her. Now you know that you signed this paper under the penalty of perjury, and you put on here that he was waving a gun at you. You know if you lie, you can get in trouble for that. And she goes, oh yeah, he had a gun. Well, it don't say nothing about no gun anywhere in here.
Irrelevant. Objection. It's irrelevant.
The issue to me is
the credibility.
No, it's not the credibility. It's the November 26th hearing. She was in the building, but what was he, let me ask Ms. Raciti, what was Mr. Meyer served with on the 26th?
I don't think he was served with the 26th. I think the 26th was the hearing that he was served with a couple of days before, because he got served with a new criminal trespass, second-degree criminal trespass, at the same time that he was supposed to have a hearing, I believe, in front of Judge Surio. Judge Surio somehow recuses herself.
We showed up for court. It got continued, but we were here.
Wait. So there's new charges.
In a different case.
Which has nothing
No.
to do with Miss O'Brien.
Nothing to do with this case either.
It's a different set of charges.
Correct.
So you served him with an amendment, or the charges in
A new charge. We served him with a new charge.
A criminal complaint.
No, he was cited. An officer.
You know what I'm saying, the ticket.
The new charge. There's 3 charges set for, there's 4 charges set for.
That's irrelevant.
For December.
There's 2 charges.
I'm trying to figure out.
She's trying to make me look like a criminal. Listen, we came here for the, she's talking in circle. We came here for the first hearing. There was a conflict of interest with the judge. When I walked out, I got served this complaint. A week later, we came back again. And I'm saying she was here both times. So why didn't she get served? I got served. She didn't. We came to the first hearing. The judge couldn't have it because of conflict of interest. She continued it. The 2 parties got up and left. Came back a week later. There's 2 times. And I'm saying they served me this thing we're talking about. And Mackenzie O'Brien was right there and I was right here. So what? So that's what I'm saying.
Judge,
That's what I'm trying to figure out.
the state did not have direct knowledge that Miss O'Kenzie was there on this first time.
If she's so important.
Whatever day it was, we did not.
They sent $35 subpoenas and all they had to do was walk downstairs. I get it. Can I keep going?
Go on.
Thank you. So we get the point, right? She was in the building. Whether it matters or not, we'll figure that out in a few minutes.
Or whether the state had knowledge.
Don't fucking interrupt me.
Let her speak, okay?
You're supposed to be this 40-year.
Go on.
So they claim they tried to serve her, right? That's where we're at, right? First they said they filed the thing on December 3rd, because I want to recap because they like to distract me. December 3rd, they filed their little motion saying dismiss it without prejudice because it's no witnesses, right? But they admit they knew as far back as November 12th they had no witnesses, but didn't file nothing until December 3rd, 7 days before the trial. And so now they're admitting, yeah, they tried to serve her, and I'm saying, oh, you tried to serve her while she was here just last week. Okay, so moving on. Then they said that the dismissal without prejudice is for good cause, not for harassment or tactical advantage, all that, which was them bringing up, when did I say that? Oh, because they didn't say anything about it not being a tactical advantage in their motion. It said essential witnesses are unavailable. They did not articulate a single legal argument in this motion why it should be dismissed without prejudice. Why they didn't say the witness still be available at. I'll continue the trial. Let's have a trial Why didn't they immediately say, do you want to stipulate? Do you want to continue? Can we continue this? We got a date. So what? She's avoided subpoenas up to here. She's being charged with perjury downstairs. And they're expecting sometime in the next 6 months, she's just going to wake up and say, you know what? I'm ready to go to trial.
I'm moving to strike. She's being charged with perjury.
It's right here.
Nothing
Case number right here.
That says that she's being charged. People make police reports.
No, there's a case at the...
I understand what you're saying. You're saying that she should be charged for...
No, I'm saying there's a case number and there's a detective with the Pima County Sheriff working the case.
But she hasn't been charged.
She has.
She has? Do you have a case number?
Judge, the.
Call
state-
detective, no, I get what you're saying. Okay, citation number versus case number in the court, maybe that we're getting into semantics.
Smart, let me stop you here right
There's a
now.
T-
I was a judge for 28 years before I got here, and never once was a witness ever charged with perjury until I was here. So I find it hard to believe the county attorney is gonna do.
It was because she lied about me having a gun. That's why
Okay, but
she lied about me having a gun.
That's neither here nor there. What happens to her is neither here nor there. The issue in my mind is, she was here on the 26th, clearly.
So she showed up for that.
Yes.
So why couldn't she show up today?
Well, the issue becomes, the problem is.
But we're not good. You wanna let me do my
Yeah, go on.
and then you can you know what I mean, give your opinion of that. You know what I'm saying? Thank you. So like they're saying it wasn't to avoid the trial, the time limits and harass me and all that, but they also can't stand here and say when this witness is ever going to be available. They can't say, oh well, let's continue it. That you know we could be available next week. Let's have trial. They just want to just put this out into the we unknown. We might so we have a proof. We have a history here. She was showing up at the pre-trials. Remember, she sat right there at one of your pre-trials. So all of a sudden now she doesn't. So she participated up to a certain point until I put the body cams on the internet and showed her lying. And then all of a sudden she tried to get an injunction to quiet me down. That got defeated. And now she disappears from. She won't show up. She won't find up. They don't know where she lives. I mean, she literally just got served the injunction for harassment papers and showed up for court. So she must get court papers and show up for court if she. It's pick and choose, right? So they're claiming it wasn't for delay. Well, then why did they wait till 7 days before when we had, according to them, we had all this extra time? Plus, if they would have said something on November 12th, so if they had November 12th till December 10th, plus this alleged extra time they're talking about, that would have been almost 50, 60 days. We could have had to schedule the new trial. But no. They wait till the last second and want it dismissed without prejudice because their essential witnesses are unavailable. Well, when will they be available? What? So my life revolves around when this 19-year-old girl may or may not be available, and in the meantime, they get to hold this over me, so I can't proceed with civil litigation? So let's move to the Rule 8 thing. We sat here, Your Honor. We had the most outrageous hearing with Matt Walker, where I got Matt Walker to admit, on the record, which is crazy that they're going to sit here and try to do this, because it's all on the record. You and I and Matt Walker went over the whole thing with Judge Cranshaw and the continuances and all that, and Matt Walker admitted on the record, Your Honor, Mr. Myers did not do that. We did not agree. He's correct about the Rule 8. He did not waive it, and he said, can we move on? And I kept going, and you're like, let's move on. I get it. It's not excluded. I'm counting that because it wasn't Mr. Myers. There was no, because they keep saying, Mr. Myers moved to continue. We squashed that at the September 18th thing when we showed, and the state agreed, Matt Walker, that I did not move to continue. That was a mistake on the paper by Judge Cranshaw, and you corrected it right there, which is the only reason we're working on this 180-day timeline is here, because at that hearing, we said, this is the 180 days. You set the October, the original one that I got arrested at, the evidentiary hearing. You said all that. We said, okay, we need time to have the evidentiary hearing. We need to have time. So 3 times that we've sat here and talked about when did the 180 start, what is excluded, what is included before today, to lead us up to deciding today could have been the trial. We've had 3 hearings where we got into the minutia of, was it excluded by Judge Cranshaw? Was it included? Was it? We got to the point. Okay. Look at the calendar. Here's the day. And remember, every hearing I said, it don't matter because there won't be no trial because they're going to weasel their way out of it. And you said, we'll see. You even told me at the hearing of Matt Walker, no witnesses, no trial, right? No witness, no case, no trial. So literally, I've been predicting this for 3 months. I've been coming in here every time and saying, Your Honor, we're just wasting our time setting this trial. I refused to sign because I knew that there wasn't. Okay, yeah, there's not going to be no trial in December. I sat here and told you, and I said, but if there is, I'll show up that day, but I know there won't be no trial. I predicted this. They call me Babe Ruth. I predict, you know what I'm saying, months ago, that there won't, I saw this coming. Because, so not only that, is the essential witnesses are not available for trial today. They haven't been available in any time in the last 6 months for an interview. I asked, they called them victims. Well, I went through the process, through the victims people. I want to interview the victim. You know, you explained it to me at the hearing.
Now, if you watched the previous hearing where Matthew Walker was still the prosecutor, Lane had to get the judge to order him to produce the witness list. And this was after another judge told Prosecutor Walker he had to do it.
You got to go through the prosecutor to interview the victims and all that. Well, I've tried to do that. I've tried to interview the police officers. They claim I haven't. I got 16 return proofs that I went on the Tucson police website and I did 4. You're allowed 4 requests with each officer on the Tucson Police Department website. I did 4 requests with each one of these officers. The only officer that got back to me was Jamerson. He said a long time ago that he would do an interview, and I said I want to talk to the arresting officer first. And then they spent months and months avoiding the officer. You had to order. So remember now, you had to order a deposition of the arresting officer because they wouldn't make him available. So now they're saying, dismiss this and give us a chance to do that again to me. So what? So now I'm gonna have. So what? Suddenly, I don't see him saying dismiss it without prejudice, and then we're gonna immediately refile it, and he's gonna be able to give it, interview all these people and all this, and the witness is gonna be available. They cannot make any guarantee beyond. Well, we're understaffed and high workload. Well, if you're understaffed and high workload, what's that? How's that going to change in the future? You're just going to have more stuff. You were so understaffed and high workload you couldn't get me to trial today. If they had the smoking gun, sir, if they had the evidence, if they could sit up here and convict me of a crime today, they would be. They would not be saying we can't. I got these people all over the internet. I got injunctions against Matt Walker's wife. I got all this stuff.
Objection irrelevant.
Go on.
Go on. Okay. And so, if they could, they'd be convicting me today, sir. These people, I'm not going to accuse them of, personally, but I'm saying, this is one where if they could put me up there and convict me today, they would be. And all these officers, I got these officers all over the internet. They want me to take the videos down, the disclosures all over the internet. There's no evidence going to be produced. And now, most importantly, since mine's in there, we're going to talk about the fact that it's dismissed as a matter of law because it doesn't even meet the standards. So case 77, they claim I said, do you want me to be waiting when you get outside? I could say that to Mary, do you want me to be waiting for you outside? Ronnie, do you want me to be waiting outside? Sir, want me to be waiting? Your Honor, you want me to be waiting when you get outside? It doesn't mean I'm going to do anything illegal to you. I could be saying, great job, Riojas. You know what I'm saying? It's such a low threshold of a charge in the first place. There's no probable cause. And under Rule 16, literally, their probable cause is that I said, do you want me to be waiting outside? That's not fighting words. I didn't say that to the guy and him jump over the counter and I start. He didn't go, oh my God, I'm scared. What are you doing? I feel threatened. He didn't do anything. I literally said.
Objection. This is testimony. We don't have testimony during this pending hearing. It's a legal hearing.
They talked about the facts of the case. But I get my motion. I made a motion to dismiss with prejudice under Rule 16 as a matter of law. I get to argue that. I'm saying I'm not talking about the facts. I'm saying probable cause. Their probable cause. It's on. The cop said, look me straight in the face. The probable cause I'm arresting for is because in case 77. In case 77, he said because you said, do you want me to, or something to the effect of, do you want me to be waiting outside? That's not probable cause for arrest for fighting words. That is not fighting words. That is not a direct threat of physical retaliation or any of that stuff. And so he said, put your hands behind your back. You said, do you want me to be waiting outside? That is not probable cause for disorderly conduct, A3, fighting words. That is not. And so as a matter of law, it needs to be dismissed as prejudice. Before we get into the Rule 8, they are trying to avoid it. That's why they waited till 6 days. You get what I'm saying?
Do the motion to dismiss fighting words.
Crenshaw stated.
The words are not fighting words, but depends on the context.
Well, they won't put the video in for the context. There's an 11-minute video to provide context, but they won't.
That's what the trial's for.
But so where's I'm supposed to be here at trial to get found not guilty. I've had 2 trials, and I haven't been able to be acquitted.
Motion to dismiss on those grounds is denied because we don't have. If we had a trial, then you could raise it.
But you don't need facts for 16.4. You can't bring in facts under a matter of law. I wasn't dismissing it as a matter of fact. I was dismissing it as a matter of law. There's not
matter of law, it's a context issue.
Probable cause.
Yes.
At no point ever can I say, do you want me to be waiting outside and it be a criminal?
It can be.
No, it can't.
Yes, it can.
Do you want me to be waiting outside? No, it's not criminal.
It depends on the context. So
The context I'm going to bring okay. So you're saying you're saying we're not even and you're saying to get into the context we need to get into the facts. Okay, so let's have trial. Twice it's been canceled. Let's have trial. I demand trial. I want to prove my innocence.
If they decide to prosecute you, you have the right to trial. If they decide to prosecute you, and the issue is whether or not that decision is final, or there's a chance to
It needs to be final because I don't need to, they couldn't, what are they gonna do different next time? And I get to keep going. They said that Cranshaw was reasons that it was excluded. We've already beat that horse to death with Matt Walker. It wasn't excluded. Cranshaw made a mistake. He set a trial date and then vacated it without extraordinary circumstances because if there was a conflict of interest, it would have been a conflict of interest before the case started, not when I filed the subpoena for Regina Romero in the Boone case. And then they keep saying, there was a motion to recuse herself. I've never put a motion to recuse herself. There's nothing.
Motion to recuse is done by the judge. There doesn't have to be a reason given.
I know.
The judge doesn't have to say why.
I'm not saying that. Hold on. I agree. I'm not arguing that. Okay. They're arguing. They are arguing. You should be telling them that. You should have been telling them that when they were talking 10 minutes ago then. When they were saying that I put in a motion asking her to recuse herself.
Objection,
or I put it.
Objection because it's right there in the motion, it's the last page.
You'll have your chance to rebut.
Which motion?
Not the motion, she's talking about the email.
Are you talking about the email or the motion?
I'm talking about the August 19th motion filed, the last page.
The one that was stricken from the record.
Asks her.
The one that was stricken from the record. I couldn't use it either because it was stricken from the record. It was stricken from the record. Remember, sir? Remember at the first hearing with Matt Walker? I even tried to bring it up to you in person. You said, well, it's stricken from the record. You got to refile it. So how is it stricken from the record?
For the purposes of why there was a delay.
Now, the argument for days doesn't really matter because that's not why we're here. Again, this hearing is to decide whether the criminal charges in the O'Reilly's case against Lane are going to be dismissed with or without prejudice. The days don't really matter.
Defense asked.
It was stricken from the record. That motion never happened. It's stricken from the record.
Okay, go on.
So the whole motion where I said it, that was stricken from the record. I don't get to use it and they don't get to use it. They claim that, because I'm writing this down, they said, and then the email counts as an email to recuse yourself. You can't ask the judge to recuse themselves. They recuse themselves, okay? And an email to her has no bearing on this, right? And then they get to the Rule 8 thing and they keep going on about how it's not to delay. It's not to delay, but they got all these, so they're claiming there's these extra 20 days or something. Schedule trial then. Let's have trial in the next 20 days then, sir. Schedule it up. Let's go. They found these magic 8 days or 18 days or something. Okay, cool. Then that means we're going to have trial in the next 18 days and I'm going to put their witnesses on the stand. Then I'm going to put the officers under oath. I'm going to question them and we're going to get to the bottom of the facts of the probable cause. Did they, didn't they? Because remember now, they rigged up a system to get me arrested at my evidentiary hearing too. We'll get to the bottom of that too though. So the one time I could get to the fact, look, we've been waiting 6 months to get to the facts. Are we ever going to get to the facts? No, because the facts prove that I'm innocent. This minutia is, let's just keep it. What purpose does it serve to keep these charges going? They're not going to bring them back. Because if they were going to bring them back, they would never be letting them go.
Well, do you understand, sir? I mean, just make sure clarify that if I do, just for the sake of argument, if I do grant it dismissal without prejudice, they have 6 months or 1 year.
I know.
So it's not going to go on forever.
No, I know exactly when. I know all that, and it doesn't matter because they're not going to refile them because they're not going to be, there's no evidence. And Mackenzie O'Brien might be in prison by then. And so there's no, so it's getting dismissed. It's just, you know what I'm saying? I'm saying they've shown no burden that this isn't anything other than, how is waiting till 7 days before? They have this novel legal theory that you and I, sir, are incorrect despite 3 hearings going over the 180, right? 3 times we've went over the 180, but they come in here today and want us to believe that 3 times you and I got it wrong, that they found some magic formula to add in these 30 days. Okay, so they found but their argument isn't, sir, that they found this magic formula to add 30 days so that we can still have trial. Their theory is we found this magic formula to add 30 days so it doesn't make us look bad when we dismiss it without prejudice. See, look, there's actually, no, we didn't do it 7 days before.
So it looks like the state has known for months that their star witness victim, Mackenzie, isn't interested in testifying in this case.
But we actually did it 37 days before. No, it doesn't matter because they didn't bring up this extra 30 days until we're supposed to be at trial today. If they had an extra 30 days, why did they say on November 12th, hey, can't find the witness, we still got 30 days, extend this out a little bit, give us more time to get this witness under here, we want a few more, this witness, this case, it's so important, continue the trial for another 20, 30 days, and give us more time to try to get this witness, try to get, but no, they want just to dismiss it without prejudice 7 days before, but they want to say, it's not prejudicial because there's really 30 days, even though there's no record of this extra 30 days at any point until today. So they're basically saying, Riojas, you can't count, and we can't figure out a difference between 180 days, and you can't read the motions that say excluded or included. And in the hearing with Matt Walker, where Matt Walker agreed that there was no continuance, Rule 8 is still in effect, 180 days, it hasn't been waived. They want to act like that never happened. They literally wrote a motion including things that we've already talked about as if they've never already been talked about. And they just stood here and argued things that me, you, and Matt Walker have already argued. We already came to the conclusion when the 180 days was expiring, we already came to the conclusion that trial is, it was already continued. We got a trial. We set a trial acknowledgement. Well, why didn't they say then? Well, we have an extra, because remember we were arguing, literally, we were arguing over 7 days. It all came down to the magic 7 days between me getting arrested, coming into court, and the next hearing that you said the week later. They were saying that was their whole pounding, they were pounding the table. We need those 7 days, those 7 days, those 7 days, and we argued about it. They didn't say, we got these other 39 days we need too. But what about these? No, they're saying, we all acknowledge, the three parties, including these two ladies sitting right here, and you, sir, that the 180 ended on the 12th, so we needed to do it on the 10th in case we needed a day or two. So here we are. So if they found magic 30 days, then they should have filed a motion to continue, gave their Rule 8 argument saying, I want to continue this. It is not to delay 180 because there's still 180. We're still within the 180, and we still want to prosecute this because we have evidence of this crime, and we want to put it on the stand and make this man found guilty. And so now it's my turn to read something. This is my closing statement, sir. You get what I'm saying? The defendant has asserted that the state was acting in bad faith or with the motive of simply harassing him for unworthy motives, intention of delay to harass or gain a tactical advantage or avoid the speedy trial requirements of Rule 8 will justify a dismissal with prejudice. That's from State v. Hall, 129, Arizona, 589 at 683. And here we go. The right to speedy trial is considered to be a defendant's right. Indeed, the United States Constitution, Amendment 6, and the Constitution of the State of Arizona, Article 2, Section 24, states this right in such terms. As a practical matter, however, as far as a guilty defendant is concerned, it is a right that he seldom urges except in those cases when, after the time has run, he perceives that his right to a speedy trial has been violated. A guilty defendant is usually content to allow the trial date to be continued until such time as witnesses have left or disappeared, the passions of the victims have cooled, and the zeal of the prosecutor has dampened. An innocent defendant, however, usually wants a trial as soon as possible in order that his innocence may be determined and he can go free. Society also has an interest in knowing who is guilty as soon as possible. Assuming that the guilty will be punished, society is then able to take from its midst, if imprisonment is indicated or under supervision if probation is granted, those persons who might otherwise be committing crimes. In addition, if there is a deterrent value in conviction and punishment, as we believe there is, the swifter the punishment, the greater the deterrent. The University of Arizona Law Review, the great institution of higher learning, has stated, the committee which wrote the rules contended that there are two advantages to society as a whole under a swift, efficient criminal justice system. The major goal of any criminal justice system protecting the public is accomplished by removing from society those persons who have committed crimes and by deterring potential criminals. The more swiftly the process operates, the more effective will be the protection of the public because the dangerous criminal is quickly removed from the streets. Also, the drafter of the rules contend, swift and certain, punishment has a greater deterrent effect. The societal interest in accurate fact-finding is similarly advanced by a speedy criminal process. The committee observed that the further removed the trial is from the occurrence of a criminal act, the less likely is a factually accurate conviction or acquittal. Thank you, Your Honor.
You dropped 150 grand on a fucking education you could have got for $1.50 in late charges at the public library.
Judge, I did want to point out one thing, that in terms of the request for the interview, the state did forward on to both the named victims in the case the request for the interview that Mr. Myers requested. The state notes that under 134433C, the prosecutor shall not be required to forward any correspondence from the defendant's attorney, or an agent of the defendant to the victim or the victim's representative. However, the state did not receive a response from either Mr. Perez or Ms. O'Brien.
So they don't want to tell what happened.
In terms of, we did not receive a response that they would submit to an interview. That's just that piece of the portion when he said that he had sent it. The state was not talking about any of the Tucson Police Department witnesses. The state had them under officer scheduling notice, so they were available for trial. In terms of actual prejudice, first of all, the argument is this. The state has moved to dismiss because it doesn't have an essential witness. That witness is Mackenzie O'Brien.
They'll never have it.
The state made attempts to serve her. The state was unsuccessful in both its attempts that it made to serve her.
Can I clarify? So they keep saying the witness, it's the victim. Remember, they fought this whole time for the victim. So witness is different than victim. Remember now, a victim, you need the victim of the crime, no victim, no crime type thing. They're talking about a witness. They're saying, they remember now, you told me that they can designate her as a victim, and they did with Matt Walker. Sorry. This unethical prosecutor can do everything he's doing, and we know why he's doing it, because I'm suing the cop that did it, and that's her little buddy. She's an undercover informant for the Tucson police, and her mommy the cops.
To stop making a record directing anything to the victim, calling the victim.
Witness. You bring the witness. You get, hey. All right. Okay, go ahead. Okay. He's saying she's the victim. He just lied to you right to your face, sir. I can show you the police report where it says Mackenzie O'Brien, witness. So twisting this shit where she's the victim is their only hope, because then they won't give me a pre-trial interview, because they're saying, and this is why Crenshaw got off the case, because we came in the thing, he said she's a victim. She's not. It's literally, sir, you have the police report, read it. I don't have it. Well, then how do you not have it when I've turned it in my motions? That's what I'm saying, sir. You don't have the police report? Then how are we standing here letting him call her a victim when the police report that I was given by the prosecutor lists her as a witness?
He's allowed to claim whoever someone's a victim.
Oh, okay. Well, I'm a victim now.
You can see the state star witness, who they're also calling the victim, has been unreachable. How are they going to prosecute their case without their victim or the star witness? Yeah, they have neither.
I was no longer allowed to talk to her when she was designated as a victim. So it's intellectually dishonest to sit here and say that she's a witness. She's a victim. Now, whether that means that victims, police officers, witnesses are all witnesses, but you get what I'm saying? For the context of this discussion, it's not an essential witness. It's the alleged victim.
Same thing.
Okay. That's up to you. But I'm making sure that it's known.
But without the essential witness, victim Mackenzie O'Brien, the state cannot proceed on either one of the two cases, either the one that happened on the 20th and the one that happened on the 26th. Mackenzie O'Brien had information that was recorded on the information of the 20th, which was disclosed to Mr.
Incomplete disclosure.
It was two. There was one for 4.5 minutes, which was a conversation.
I thought you said I could put, they could enter exhibits, so why can't I exhibit? Can we watch the body cam?
Just sit down.
Can we watch the body cam?
No.
Anyhow, but here's the issue. The issue is either the state grants the motion.
Court.
Either the court grants, thank you. Either the court grants the state's motion to dismiss without prejudice because the essential witness is unavailable, which is what we've asked. That is not a reason to avoid the purposes of Rule 8. We have demonstrated to the court how the state's motion, because we don't have an essential witness, that we can't go forward without. That doesn't say that, and plus, if the state was doing it to avoid the purposes of Rule 8, it's the court's discretion to decide whether or not that dismissal should be with or without prejudice. We're showing that the state did not try to avoid the purposes of Rule 8 by looking at time should be excluded. And the date that we're talking about is the 30 days between Judge Mayhew's being asked to recuse herself and her recusing herself. That's 30 days that was for the defendant's benefit. It didn't help the state at all. It didn't help the court at all. This court was appointed, you, Judge Riojas, were appointed sometime between the 18th and between the 19th and the 18th of September, which is when we have this hearing. So those days.
I believe it was like August 30th and September 18th.
It was August 19th through September
17th.
September
18th
is the date that was the hearing with Mr.
Matt
Walker
Where I destroyed him in court for the whole world
And
to
the
see.
state was not asking the court to exclude the time when Judge Cranshaw had written excluded. Sounds like it was addressed at the 18th hearing in September. But there's no actual or legal prejudice under the Quigley case that applies to this particular instance. So grant the state's motion to dismiss without prejudice. 13107 runs on June 8th of 2025. If the state has not refiled the case within that time, based on good reasons, if the state would have to look at refiling the case. I mean, what the reasons would be for the state to refile the case. If there are actions taken against the state's essential witness, I'm not going to be able to predict that. But the state does ask for this dismissal without prejudice. Thank you.
Sole issue is with or without prejudice.
Based on the availability of a witness that may or may not, so they have no, she's not available now, she won't be available then, she's refusing to show up.
That's sort of speculation. I would,
So are they.
Yeah, but they get the benefit down. I'm going to grant the motion to dismiss without prejudice.
And even after all the shenanigans that happened in this case, the judge still dismissed it without prejudice, meaning the state can still refile the charges. But it looks like Lane's already a couple steps ahead and is working on his next move.
I'm gonna appeal it to special action anyways. That's what I'm saying, that's why I wanted to get everything on the record, right?
Yeah, June 8th, Judge, looks like it falls on a Sunday, so
June 9th.
technically we could file by June 9th.
And that's because the unavailability of the essential witness.
I get it though, you work for them, but I get it, I'm not accused, I get it, it's all good. I got options. I got a good, nice legal defense fund that we can spend $300 on a special action and get this shit dismissed anyways.
And Your Honor, when we all receive our paperwork, may we all be excused?
Mm-hmm.
Thank you.
You're excused from class, Mary. Hope you learned a valuable lesson, not to fuck with Lane Myers. Because you'll be all over the internet looking dumb. And now your ass got a bar complaint for no probable cause. Thank you for considering the issues, Your Honor. It's all on the record. That's the good part. For me. The reason they won't be able to refile him because Mackenzie will be in prison for perjury. So we'll see. Do I get to ask for interviews and stuff while it's dismissed without prejudice?
No, I don't think so.
I don't get to order depositions?
No.
Oh, that's too
Unless
bad.
file civil action, I guess.
Oh, that's already been filed. That's why they're doing this. So the federal lawsuit got filed yesterday.
Those are gonna be.
That's all this is about. December 3rd, they filed the motion to dismiss without prejudice because on December 4th, filed the federal lawsuit. You know what I mean? That was when my little notice of claim expired and all that stuff. Now go sit in timeout, Mary, and think about what you did. How you prosecuted an innocent man and wasted his time for 6 months, only to get found out looking stupid. Your Honor, we found 180 days. Hey, Your Honor, would you give me a reference if they said they're overworked and understaffed, would you give me a reference if I applied to the Tucson Prosecutor's Office?
No, I can't.
You can't give me a reference? You can't give me a reference on my legal acumen? It should be that anytime you beat these.
Well, unless you gotta have a law degree to work for an attorney.
It doesn't seem like a law degree even helps. I put Stacy Jane in the ringer down there, and she was supposed to be the best lawyer in town, and she got the smoke show right out of here too. So let's see, what is that? 9? That's 10. That's 10 cases dismissed in the last 2 weeks. Not bad for a pro se incompetent idiot.
There's also this one here.
Huh, Ronnie? Ronnie Byrne.
Go ahead.
Hey, Riojas, and guess what? We get to do it all over again.
It may not be me.
In another case. Oh, it'll get to you, trust me. It'll get to you. It'll get to you because I'll send an ex parte email and then they'll recuse themselves and then, you know what I mean? And then all of a sudden we'll have to bring in Riojas again because he's the only one that can keep this guy on track.
You better stay alive, Mr. Riojas.
That's what I'm saying. We're counting on you, Riojas. What's that?
This is your.
Orders.
Hey, it don't matter now, but the prosecutor don't serve the courts. You know what I'm saying? Like.
Did you want me to hand it back to her so she can hand it to you?
For what?
No, just go on.
Or you want me? Is I'm supposed to sign something?
No, it's just.
No, I just didn't know if you.
But I'm saying it doesn't. I mean, in this case, it don't matter. But like, so you put that thing on the 4th. They closed the case on there. You can look it on there right now. That it says.
That was them, that was us.
No, I know. But I'm saying, right? And so they're saying, they're noticing me of service. They're saying, oh, yesterday at 2 o'clock, they're saying, what are you talking about? Notice of appeal. You have court tomorrow. And I'm saying, the court don't say that. And then at 2 o'clock in the afternoon, the court website changes to say that I have court today. It's not efficient, you know what I mean? I know.
I would admit there's issues.
Because to this day, I've never seen your order on the 4th.
No?
Because you did something to vacate the trial.
Yeah, I said, said legal hearing today, so.
And I didn't know about it till
Make a copy of that order.
till 2 o'clock yesterday, you know what I'm trying to say? So it wasn't even like I knew this was happening until yesterday at 2 o'clock.
Yeah, that's it.
But I'm glad, hey, thanks for having a hearing though, for sure.
And I figured you want to have your
I
say.
I need to get on the rack, you know the deal. We're all.
All right.
Yep.
We'll make a copy of that order.
Right, because it never, you know, then the state saying, well, you got to be there in the state. I'm saying the state, you don't control when I get.
Part of the problem is I don't have a regular courtroom, I don't have a regular JA, so stuff gets lost in the creases and cracks of the courthouse.
Right, so you make the order and then it has to go to somebody else.
If it was a regular judge, would get handled different.
Oh, you're not a regular judge?
Well, I'm not a regular judge at full duty here.
Hey, you already knew that. Hey, if you need some betting tips, let me know. I called the right? I called the future, right?
Yep.
If you need me, I said there's no way there'll be a trial on December 10th. Your Honor, would you give me a reference if they said they're overworked and understaffed? Would you give me a reference if I applied to the Tucson Prosecutor's office?
No, I can't.
You can't give me a reference?
There's.
You can't give me a reference on my legal acumen?
You gotta have a law degree to work as an attorney.
It doesn't seem like a law degree even helps. I put Stacy Jane in the ringer down there, and she was supposed to be the best lawyer in town, and she got the smoke show right out of here too. So let's see, what is that? That's 10 cases dismissed in the last 2 weeks. Not bad for a pro se incompetent idiot. That's the same shit they did to me, gave me the ticket in the back of the car, and then told me I had to go get fingerprints. I said I'll cut my arms off before I go get fingerprints.
And that's the end of the hearing. Now, make sure to go over to Lane's channel and give him a like and subscribe. And if you'd like to donate to Lane, that information will be found in the description below.
Our channel is Dark Times with Nico Inside. If you'd like the video, please make sure to give us a like and subscribe.
Thank you for watching.
Thanks for watching.